Hi everyone, we are here today for video 3.1.9 for the Legal Studies Guide. Our quote today comes from Unknown, who is very famous for lots of great quotes. I'm sure someone probably made this up in their basement somewhere. Pretty simple one. If you want something you've never had, then you've got to do something you've never done. How does this apply? Well, every class I've ever taught has included a kid who has lamented and complained and moaned about not getting the marks that they want, not going as good as they'd like. And there's always, someone to blame. It's always someone else's fault. Sometimes it's what I've done. Sometimes it's something at home, and look, I understand that there are circumstances that make things difficult sometimes, but it comes back to this quote. If you're going to complain about your marks, so you want something you've never had, which is better marks, then you've got to start doing something you've never done. So think about how that might apply to your approach to study, particularly as we near the end of Unit 3, Area of Study 1. In 3.1.9, we are covering off the responsibilities of key personnel in a criminal trial, and again, our favourite word, including the judge, jury, parties, and legal practitioners. So again, you could be given a vague question around, explain the responsibilities of key people in a criminal trial for a certain number of marks, and you'll be expected to, I suppose, work out how much to talk about each person. But the other thing that could happen is you could be asked specific questions about the parties or the judge or legal practitioners. Where I think they're most likely to use this is in case studies and scenario style questions, and they're perhaps likely to, on some occasions, potentially give you information that is wrong and ask you to pick up that perhaps a barrister doesn't do that or a judge doesn't do that. But also maybe just mention something about the judge and then ask you a question on the lines of explain the role of the judge in regards or in relation to this case study. We need to discuss the responsibilities of key personnel, so I'll talk about that one a little bit later on. That means we have to be a bit strategic with how we look at this. So our essential question is, what role do each of the judge, jury, parties and legal practitioners play during a criminal trial? And we'll be able to answer that at the end, I hope. So, as we said, it is an including section of the study design, so there are very clear guidelines about what we need to know or who we need to know about. That being the judge, the jury, the parties, which covers the prosecution and the defence, and then legal practitioners, which covers barristers and solicitors. Okay? The language the study design uses, and I'll go back to that quickly, is the key responsibilities or the responsibilities of key personnel in a criminal trial. Okay? Language is important. This means we're focused on what happens in the county or Supreme Court. Okay? So matters that are resolved there, so as we know, for indictable offences only. Just to be clear with the language, if we're talking about the magistrate's court, we're going to refer to that as a hearing. Okay? Or if we're talking about an appeal, that's also known as an appeal hearing. Okay? When it comes to actual trial, we're only talking about indictable offences in the county or Supreme Courts where there's a jury present. So what roles do each of these people play? Well, first up is the judge. And as we know from our opening presentation on the principles of justice, the judge is all about being impartial. They are the third party. And we're going to talk about the two other parties in a moment. The judge enforces the rules of evidence and procedure and applies them equally to both parties. That means they direct the procedure, the process, whose turn it is to go when, whose turn it is to call witnesses, and they decide on the rules, or not on the rules of evidence, but they apply them equally as well. They decide what evidence is admissible and inadmissible. So when they're doing that, they're looking to make sure that all evidence that is presented is probative as opposed to prejudicial. So probative meaning evidence has to prove something, as opposed to prejudicial, which doesn't prove something, it might be hearsay, etc., but it will make the jury believe that a person is guilty. An example of that is a judge would not allow someone to give evidence if they were going to get up on the stand and say, oh, yeah, well, I know that Bob killed Jennifer because Tony told me, and Tony told me that Bob told him. That's what we call hearsay. You can get up on the stand and say, Bob told me that he killed Jennifer, okay? But you can't get up on the stand and say, Tony told me that Bob told him, okay? Because that might not be true. So the judge would be responsible for saying, no, that evidence is inadmissible. They decide questions of law, okay? And that rolls into that idea of rules of evidence as well, admissible and inadmissible. And they instruct the jury on the law. So they would instruct the jury, for example, in a murder trial, they would explain very clearly what intention means and what malice aforethought means, and what the jury must be comfortable with to find someone guilty of murder. So those extra elements. If the offender is found guilty, they are then responsible for sentencing as well. Okay? So the judge is kind of there as this, they obviously have a lot of legal knowledge, but they're there to make sure things run smoothly and things are done justly and fairly. And they do this by applying rules equally. Okay? So there's a lot of information there about principles of justice. Part of the judge's role, as we said, is to instruct the jury, and the predominant role of the jury is to deliver a verdict. So in a trial in the county or Supreme Court, you must have a jury, and the jury will decide if you are guilty or not guilty. The jury will be made up of 12 randomly selected members of the community. These 12 random members of the community will sit there, and their responsibility, and they can take notes if they want, but their responsibility would be to listen to the evidence and assess it. Okay? So they have to listen objectively, they have to listen without prejudice towards the witness or the victim or the accused, and then they have to assess that evidence, and they basically have to decide whether they believe that that evidence is true in some cases, if it's witness testimony, how much weight to lend to certain forensic evidence, because there are examples of cases where the prosecution is trying to link a chain of circumstantial events together, Well, we have evidence that this person was near the location at the time, and we have evidence that they wanted the person to die, but we don't actually have a gun, for example. So the jury then has to assess that evidence and decide if they believe that there is any doubt. Okay? Because they have to deliver their verdict of guilty or not guilty. Or if they deliver a verdict of guilty, it has to be beyond reasonable doubt. They'll be instructed by the judge. They might be told by judges or by the judge at times to disregard certain evidence, or that they can't include certain evidence in their proceedings if it's been objected to and ruled inadmissible. And they'll go away to deliberate before they reach their verdict. And this could take a number of days sometimes. As they go back through the evidence, they can ask questions of the judge, and they discuss amongst themselves effectively whether the person's guilty or not. We then have the parties, and no, not a party in the sense of come round to my house from 6 p.m. to whatever, way back in 2007. This looks like a horrible party to attend, I might add. Nonetheless, I'm sure this guy had a fantastic time with his hose water. The parties are responsible for presenting the evidence and making the arguments to the jury. So the judge doesn't at any point stop and say, oh, well, hey, just so you know, he said this, or he said this, or I think you should do this. It's all up to the parties to bring their own evidence and make their own arguments. And the judge doesn't support them with that. There are two parties in every criminal trial: the prosecution, who works on behalf of the government, and the accused and their supporters, usually, obviously, lawyers. As I said, both parties have full responsibility for their own case. They have to gather their own evidence. They have to develop their own arguments. They have to present them in a compelling way to the jury. The prosecution, as we know, is attempting to prove the case, and they have to prove it beyond reasonable doubt. The defence does not necessarily need to bring any evidence themselves. They can sit there and present no evidence. However, naturally they usually do, and their job essentially is to cast doubt on what the prosecution has brought forward, or bring forward their own evidence completely that tells perhaps a different story of what occurred in or during an incident. Effectively trying to make sure that there is doubt to what story the prosecution is putting forward. That way, hopefully, the jury will give a verdict of not guilty. The key people who are presenting these arguments and preparing them and presenting the evidence are the legal practitioners. So they use their legal expertise to support the parties to try and get a positive outcome. Whether that's a guilty verdict or not guilty verdict will depend on which party it is. These lawyers are obviously trained. They have to be have passed their law degree. They have to be admitted to the bar if they want to be a barrister and present arguments. And effectively, if you don't have one, you are limiting your chances of having a positive outcome to your case. Barristers are responsible for presenting the case within the trial. They're the ones who, you see on TV shows like Boston Legal or in the courtroom scenes in Law and Order. They're usually, impeccably dressed, well-spoken, use emotive language to get the jury on their side. On the other hand, you have solicitors who are also lawyers, but more behind the scenes. They provide administrative support. They'll file all of your paperwork. They'll sit down with the barrister and they'll brief the barrister on the case. So the solicitor will be like your ongoing contact in a law firm. If you're a defendant and you've sourced your own legal representation, they'll be your ongoing contact. They'll manage your case. They'll make sure you know when you've got to be in court and your paperwork's filed and witnesses are organised and that sort of thing. And then it's the barrister who'll come on the day, the rock star, and he'll ask the questions and he'll, or she, obviously, will show off to the jury and basically sell the case. They're like legal salespeople, essentially. The prosecution will always be represented by a legal professional. Crown prosecutors are employed by the government. They basically sign a contract that says the only work we'll do is prosecution work, and they go to court on behalf of the government, and they're instructed by a solicitor from the Department of, or the Office of Public Prosecutions. It is the responsibility of the accused person to get their own legal representative. Sometimes this will be applied for through legal aid. If you do not have someone like this to present the evidence, you are undoubtedly most likely going to lose. It's an interesting one, this skill. This skill is asking us to discuss the responsibilities. What I interpret that to mean is, obviously we know discussing something involves an exchange of opinions. Now, the way I have decided, and I believe that this should be interpreted as a skill, is that what we actually need to know is what each key personnel, like say the judge, in terms of an exchange of opinions, we need to know what they do, but also what they don't do. Okay? Because the way, again, as I said, I'm interpreting this, and I believe that this will come up in an exam, is we're going to get given case scenarios, perhaps, or similar, maybe a short case study just with a couple of questions on it, or maybe a longer case study that has 20 to 30 marks worth of questions. And at some point, it will mention something about what the judge is doing. And the question might come to us, explain the role of the judge in relation to this question. And we would be expected to be able to say, well, the judge does this, but in this scenario, they're actually doing this, which is something they don't do. So we need to know both sides. Or it might say, discuss what role the judge would play in this case. And we need to be able to say, well, the judge will act impartially and apply rules of evidence and procedure. However, the judge will not question witnesses or make arguments to the jury. Okay? So we'd be discussing that and exchanging our opinion on what the judge does and what the judge doesn't do. Here is a couple of lists to help you. So as we just looked at there, the judge applies the rules of evidence, instructs the jury, resolves points of law and sentences if guilty, but they do not assist parties or decide questions of fact. A jury will decide questions of fact, but they don't resolve points of law, kind of the opposite of the judge, and they don't sentence a guilty offender because that's the role of the judge. So you can imagine a scenario where it says, the jury found the person guilty and the jury sent them to prison for a year. This is something that a jury doesn't do. They decide questions of fact, they deliver a verdict, they apply the facts as they see them. Barristers and solicitors are ones that we would potentially need to know about. Barristers examine witnesses, present arguments to the jury, but they don't file the court paperwork or provide the ongoing legal advice because we know that's what a solicitor does. The solicitor will also brief the barrister and support them in the courtroom. For those of you who have seen The Castle, and if you haven't, I recommend watching it. That's the role that Dennis Denuto plays, the very poor lawyer from Melbourne who originally supports Daryl Kerrigan. And his support of the barrister in the courtroom is to pass notes asking if the barrister would like a glass of water or not. Generally, what will happen in a trial is solicitors might pass notes instructing the barrister to check a certain part of the law or maybe ask a certain question. The solicitors will not present evidence and arguments to the jury. Just further on solicitors aren't always working in the courtroom in matters like this. Solicitors are also the lawyers that you might have in small country towns are generally solicitors, and they're the people you would go to and meet with in their office just to draw up your will, doing things like conveyancing, which is transferring property titles between people, and things like that. So there are lawyers who don't actually work in courtrooms, and those lawyers are also solicitors. The prosecution, as we know, they attempt to prove beyond reasonable doubt that the accused committed the offence, and the defence, what they don't do is they don't have to prove that they didn't commit an offence, they just have to attempt to discredit the prosecution's evidence. So as I said, it looks like the sort of scenario or the sort of skill where we're going to get case studies, perhaps along the lines of this, where Melissa's been charged with an indictable offence and will stand trial in the magistrate's court. She is unable to afford a lawyer, but is confident that the judge will help her, as she has seen her on TV before. She is confident that she will prove that she didn't commit the crime. Identify 3 errors with the scenario and outline why they are incorrect. Hopefully you've picked up the error regarding indictable offences in the magistrate's court and the like, but we just want to focus on the one that is to do with the responsibilities of key personnel. And that's particularly here where she says, but is confident that the judge will help her. So what we would be expected to do on an exam here to get our 3 marks is say, 1 error is that the judge will be able to help Melissa. And then in terms of outlining why that's incorrect, that's where you'd start outlining and say, well, the role of the judge is actually to be an impartial third party, not to aid parties who don't have legal representation. And that way you'd ensure you get that mark. Your other error is obviously that indictable offences are not heard in the magistrate's court. And here she is confident that she will prove she didn't need to commit the crime. Well, she doesn't need to prove that. The prosecution needs to prove that she did. In terms of principles of justice, I mentioned particularly with the role of the judge, lots of links here. So take a moment to try and fill this out yourself, and we'll flick over in 3, 2, 1. So obviously the judge achieves fairness because they're impartial, and the fact that parties have control, like we showed, means they'll ensure that the best evidence is presented, and that should mean that the outcome is fair. Where fairness isn't achieved is that juries are not trained to put aside their prejudices and biases, so therefore the outcome might actually not be based on impartiality. It might be based on the fact that 3 of the jurors think anyone with tattoos is a criminal, okay? And therefore that's not fair. Also, it's not fair that the judge is unable to help unrepresented parties, meaning that they might get an unfair outcome. Both parties receive no help from the judge, as we know, which is equal. Every trial for an indictable offence uses a jury, again, equal. But we could also argue that the parties are not on equal terms, because the prosecution will always have a lawyer. They'll also always have a barrister from the Crown Prosecution Service. And they obviously have the resources of the state to pursue cases. You don't as an individual. But that's maybe where legal aid steps in. And we're seeing some links through the study design here. In terms of access, legal representatives are great for ensuring people understand proceedings, but not everyone can afford it. Again, links here to legal aid. So there's your links through to the principles of justice and obviously to some earlier content. In terms of synthesizing and applying here, as we go a bit haywire, to actual or hypothetical scenarios, one that I'll link you to is just this article from a range of newspapers, and you could just look it up, search for man living in body, but I'll post the link in the comments. This is a case about a person, I forget their name, but they weren't happy with their registered name being used in the trial. They said that their name was actually man living in body. This drew throughout the case the ire of the presiding judge, who on several occasions got quite angry with man living in body. And if you read the article there, you'll see basically that the judge was instructed that they, by a higher court, that they weren't being impartial. So they really towed the line of impartiality. So I recommend checking that one out. In terms of what else you could do to link, I would highly recommend that now that we sort of have a bit more of an understanding of some of the pre-trial stuff, this is where you could start constructing your own case study. So what you'd be looking at doing there is using some of your knowledge perhaps from Year 11 legal studies of different crimes. You could perhaps write up what occurred in terms of the crime, but then start talking about, okay, this is what would happen during a committal hearing, this is what would happen at trial, this is what the barrister would do, this is what the parties would be doing, this is what the judge would be doing, to really build your own knowledge and apply it to your own situations. In terms of the different levels of knowing, which we've looked at previously, you know, just knowing down here, understanding, and all the way up to evaluating, there is some theories on Bloom's that above evaluating, up here is one of the hardest skills and the highest levels of knowing is being creative, and applying that to your own scenario that you make can have a really, really good impact on your learning. So I'd recommend you write that one up and have a go at that yourself. As always, concluding, can we answer our essential question? So our essential question today was, what role do each of the judge, jury, parties and legal practitioners play during a criminal trial? Have a crack at that. If you can't answer it, ask your teacher, ask me, look through your textbooks, and once you're done with that, head on to 3.1.10. Leave a review below or on Facebook. Hope you enjoy.